Welcome to another episode of. We've actually rebranded the podcast, so it's actually called the 1% Club. And then if Tofik can just introduce our guest today, our very special guest.
Yeah, today we're introduced by a special guest, and it's going to be a really great episode. We're joined by Bita Di Lisi from Stonegate. She's a paralegal, and she's my go-to whenever I have a problem with tenants or landlords. So thank you so much for coming, Bita.
Thank you for having me.
Awesome.
Thank you.
We're very excited to do this because I know this is the hot topic these days, tenants, landlords.
I know, landlord-tenant board. I know there's a lot of delays. Like, what kind of delays are we seeing nowadays?
So it doesn't matter what application or notice you put forward, there's no quicker way to get to the board. The delays are 7 to 8 months, sometimes longer, to receive a notice of hearing. Now, that doesn't mean you're going to be heard in 7 to 8 months. That just means, congrats, you've received a notice of hearing.
Just
right?
the notice.
Just to receive that notice.
And it doesn't matter whether it's N12.
Doesn't matter. There's no quick way. I have many landlords who say, well, if we're owed $10,000, $30,000, is that quicker? A non-payment of rent quicker than an N12? Doesn't matter what the notice is.
Yeah. Recently, I heard that the landlord and tenants board, they hired more staff. Do you think that's going to help? Or?
Well, they actually, the province has injected $6.5 million into the tribunals, and the landlord and tenant board being one of them. And they've hired on more staff. This is going to help, but keep in mind, how long does it take to hire someone, train them, and have them be as efficient as everybody else?
Yeah.
It's still going to take time. In fact, often hiring new employees adds to the backlog because they're a little slower in getting to hearings and issuing orders than the previous people.
True, makes sense. Before we get into more questions, can you just introduce yourself? How long have you been in the business? When did you start?
Absolutely. I'm going to age myself a little bit here. My background actually lies in real estate. I obtained my real estate license back in 2004, 2005.
Okay.
Probably when you guys were still.
Yeah.
And through that path, I started inquiring landlords and investors. And those landlords and investors purchased small to medium-sized apartment buildings and commercial plazas, but they weren't in the country or in the province to deal with the day-to-day operations. So just like all my real estate counterparts, I offered to manage their properties. And alongside my husband, Rob, we started a property management company. And through that path, we would often end up going to the landlord and tenant board. And at the board, 9 times out of 10, my matters would get dismissed because I was not a licensed paralegal or lawyer.
Okay.
Right.
So I went to I went back to school because I love learning. I obtained my paralegal license. And now with our real estate background, my firm provides support to agents like yourselves throughout the province when it comes to landlord and tenant matters. So that's our background. Although we have a real estate background, we do only legal services in the realm of landlords and tenants.
So you got into real estate and then you were really passionate about helping, obviously, the tenant landlord side of things. So is that your full time now, or do you still practice real estate?
I don't sell real estate anymore. Our firm keeps us really, really busy.
Yeah.
And we have a team of 5 paralegals, so they are able to assist landlords and agents. But we do have a real estate background, so we do know that oftentimes agents don't really know how to deal with these type of matters. And so that's where we come in, because we were agents before we were legal reps. So everything that agents are trying to do now, we've done. Trial and error.
Yeah.
So that's why we say as agents, definitely, get in touch with us if you or your clients are having difficulties with these matters.
Right. You understand where we're coming from.
Exactly. We understand where you're coming from. We know the lingo. We understand that the agreement of purchase and sale has a deadline. So if you have a landlord who sold a property and a buyer who requires possession, we know that time is of the essence. So if that closing deadline is not met in time, there are some strong consequences to that seller landlord.
Can you briefly expand on that then?
Yeah, absolutely. Oftentimes we have, seller landlords who want to sell a property, and they can do so with the tenant inside. Now, once that property is sold firm, meaning there's no conditions in an agreement of purchase and sale, the tenant can be notified by way of an N12, like you had mentioned, in order to vacate the property. Now, The N12 is just a notice. And what that means is I'm putting you on notice. I've sold the property and you have to leave in 60 days. But that notice doesn't really bear weight unless it's backed up with the landlord and tenant board's sorry. And that order can be enforced if, for example, the tenant doesn't leave by the termination date in that order.
Oh, wow. So the N12 itself is obviously just a piece of paper. There's no legal liability for tenants
Exactly.
to actually leave the property.
Unless it's backed up by an order.
So the order is needed then.
Absolutely. So if the tenant leaves, it's all good. You don't have a problem.
Yeah.
But sometimes we have those tenants that say, I'm not going to leave unless you give me some money, right? So there's to a point. I mean, some landlords can't afford to give 30, 40, 50,000.
That's a lot.
Right? That's a lot of money. And why should they? I mean, they took the risk. They purchased this property after tax dollars, just to get by. And all of a sudden to have someone say, I want all the rents back, whatever I paid you, plus thousands more in order to leave. They shouldn't have to do that. The reason why they're resorting to this is because of the delays at the board. Because they know that it's highly unlikely that that buyer is going to wait 9 months, 8 months to receive that notice of hearing.
So the tenants are taking advantage.
There's a lot of tenants that are taking advantage.
Yeah. And I think because, I don't know, maybe you can correct me, but I think a lot of tenants, they think that all landlords, they're filthy rich and they own 20, 50 properties, but that's not the case.
That's not the case. Not the case. Many landlords, especially the small landlords, are immigrants.
Yeah.
Right? And immigrants, when they come to this country, they work hard. I mean, everybody works hard, right? But immigrants work extra hard because they want to get ahead.
Yeah.
And when they save those after-tax dollars in today's really competitive real estate market, and they buy that investment property, only to find out that when they sell it, the tenant wants a piece of the pie.
Yeah.
Right? Like, so for example, yesterday, I was having a discussion with the tenant's legal representative because my client had sold the property. It was a $3 million property.
Okay.
And the tenant was living in the basement. And the legal rep, believe it or not, told me, my client has been living in your client's home for the last 7 years, and they've paid down $250,000. You know where that's going, right?
Yeah.
And I said, okay, well, they would have had to pay anywhere
Yeah.
they would have had to live. So whether it's an apartment building or somebody else's basement, if they wanted to own a property, if they wanted the equitable benefits, they should have bought a property.
Yeah, true.
Right? But now they want $50,000 in order to leave.
That's crazy.
It is. It is.
So okay, what happens now? Let's say you're a landlord, you want to sell your house, it's firm. You give the tenants the N12. The closing date comes.
Time is of the essence. You need an order. So you need to first go to the board. You need to convince the board that, yes, the property is sold. Here are the buyers. The buyers here are here to testify that they're going to be moving in. You now need to convince the board to end the tenancy. Right? It's not even a guarantee at the board. Remember, the sale of the property is not relevant to the tenancy. It has nothing to do with the tenancy.
Yeah.
Right? You want to sell your property? Knock yourself out. Sell it.
Yeah.
But the tenant doesn't have to leave because you want to sell it. Now, the alternative is a cash for keys.
Yes.
Have you guys heard of a cash for keys?
From you.
Cash for keys, from me. Yeah.
Cash for keys.
Cash for keys is basically offering a buyout in exchange for a termination of tenancy, $50,000. But we've had crazier offers. We've had, believe it or not, we've had lawyers tell us that their tenant client wants us to buy them a piece of land so that they can build their house.
Oh my God.
You know, we've had tenants say, we want you to go and buy me a house so I can continue to live there. Like,
Really?
we've had
Buy
crazy, yeah. Believe it or not, we've had some crazy offers.
Wow. So a seller or landlord, they once they sell the property, or even if it's a lease, like leasing to a new tenant, because there was an agreement that the current tenant's leaving, there is no guarantee that the seller or landlord can guarantee vacant possession.
That is a great question. I always say in this day and age, there is no guarantee. Even if that tenant gives you notice, you still should wait until you have the keys in your hand in order to re-rent it.
Oh, wow.
Yeah, because what happens if the tenant says, well, you know, the day before he's supposed to give you the keys, I can't find a place.
Yeah.
Or my new landlord has changed his mind. I have nowhere to go. Meanwhile, you've signed a new lease with someone. They're supposed to move in, and guess what? Now you put yourself in a very, very difficult position.
Like just so you know, how often does that happen?
It happens more often than you think. I would say about 3 out of 5 landlords find somebody else before they receive the keys. And you know why? Because they say, I can't afford expenses.
To leave it vacant.
Like 15 days or 1
Exactly.
month. Yeah.
But what does that matter? Because you have 30 days to find someone and you're still going to get the first and last month's rent.
Right.
Right?
Unless you're using a realtor then.
Unless you're using a realtor, then yeah. But you're using a service.
Yes.
Right? And you're using a reputable service. So you're using someone who has the experience, who has the knowledge, who has access to the MLS. Using the realtor service to find a tenant or pre-screen a tenant is one of the best services that you can use.
As long as you find the right
As lo-
experienced one.
That's
Yeah.
right. That's right. And that comes over time.
What's the agreement to lease, like the paper, the schedules? Obviously, some landlords include clauses in there that are supposed to be against the landlord-tenant board,
Yes.
so they're not really valid, are they?
No. And I'll tell you why. Firstly, any term or clause that's contrary to the Landlord and Tenant Board's rules or contrary to the Residential Tenancies Act is automatically void and unenforceable, even if the parties agree. So if you rent my unit and you say, I'm not going to have a pet in the unit, and I say, no problem, you are the ideal candidate, here's the lease, here's the keys, move in. And then I come to do a maintenance, I come to change the furnace and I notice you have a little dog.
Or 10 cats.
Or 10 cats. We've had that happen too.
Yeah.
There's nothing that we can do because the law says that you're allowed to have pets.
Now, what if the condo bylaw or the condo law says you can't have pets in the building?
Let's talk about that. That's a great question because that is an exception.
Mm.
Now, for that exception to bear weight at the board or any court, they will ask you, listing agent or cooperating agent, did your client receive the rules of the condo board? Right? Did you inform them that they cannot have a pet prior to them signing the lease? I hope you did, right? Because if you didn't, you're going to be in very big trouble.
Yeah.
Right? You're going to pay damages because they relied on you.
The realtor will be.
That's right. Yeah.
So if the condo board allows it, that's a different story, right?
That's right. If they allow it, they allow it. But if they don't, they don't. As realtors, you should always include the condo board's rules or the condominium's rules with respect to pets and smoking.
Mm.
Always.
Yeah.
Because those are the most common issues that arise.
And you should always provide it to the tenant before they move.
100%. 100%. And in fact, one step further, get them to initial. Right next to smoking, right next to pets.
Right.
Right? This way, if they say, well, I didn't receive it or I don't have a copy, well, this is your signature,
Initial it.
right? There you go. Yeah, this is your initial.
But if it's a house, freehold, and then
Fair
the
game.
landlord finds out there's pets, there's nothing they can
Fair
do.
game. I always tell my landlords, and I'm a landlord myself, and I know that there are risks to owning real estate for rental income. One of the risks are pets. Another one is that the tenant will damage the property. Another one is that they won't pay rent or they'll be late. Another one is they'll bring their, boyfriend, girlfriend, aunt, uncle, mother, father into the property without your knowledge, without your permission.
Yeah.
They might get a roommate, they might rent the room, or they might Airbnb the room without your permission. These are all risks.
And there's nothing you can do
And
about it
there's
as a
nothing
landlord.
that you can do.
So if you sign a lease for 2 people and then you find out that there's 10 people in the house.
Because occupants are allowed, right? Roommates are not recognized under the act, so they're not protected. And they're allowed to have guests and visitors. Even guests and visitors who stay 7 months or 8 months.
Oh, wow.
But based on fire code, I believe there's a legal limit to how many occupants can.
That's correct.
Space, right?
Based on the city bylaw occupancy
City bylaw.
limits. Yeah. But even that, a landlord doesn't make that determination.
They
So
don't know.
exactly. So even if you inquire and you find out, well, 10 is the limit and Bobby is bringing in, there's 12 people living there, you now have to apply to the board, take the matter to the board, have them testify that they're living there, and have the board basically decrease the size of the number of occupants.
Right.
But they will issue an order, which again, how long does it take? 7 to 8 months.
Wow.
Just to get the hearing date.
Just to get the hearing date. And I'll tell you, I've had many times that we've gotten the hearing date, we're prepared to attend, right? Everybody's ready, we attend, and there's technical difficulties. The adjudicator, believe it or not, forgets to attend. The adjudicator forgets to attend. Our witness is not, cooperating. Like anything can happen.
Or they need translation.
Or they need translation.
Right?
Or they're asking to reschedule because they need time to get a legal rep, even after 7 to 8 months. I know.
This is ridiculous.
I know, but they have the right to representation.
So it can go to 1-2 years, like.
Possibly.
Mm.
I have cases that are just being heard because of so many delays from 2019.
Oh my God, that's
Really?
4 years ago.
That's right.
Wow.
I have cases where they've been going on since 2019 and the board has changed systems to a new portal and they've lost the file.
So what's happening with the owners of the properties then? Like obviously they're having to pay out of pocket. Like do they sell the properties off or?
Some of them do. I know that during COVID time we had there was about 4 or 5 landlords that just dropped off their keys and says, "I'm defeated. I can't do it. Not getting the rent. They're not paying utilities, damaging the property. I can't sleep at night. I'm having problems with my family," and it's sad.
It is.
It's sad because people are really losing their properties.
So based on what you're saying, clearly, like Ontario, it's leaning heavily towards the tenants' favor.
Well, let's talk about that.
No.
Because many people say the law is always for the tenants, okay? It's always tenant friendly. And I say, no, it's not. The law provides a balance for both the landlord and the tenant, okay? But here's the problem. See, pre-COVID, if you were to come to me and say, Tafik is not paying me rent, right? Let's serve him a notice. Let's get him out. We would serve a notice. We would be in front of the board in 60 days. By 90 days, he would be out.
Really?
Yeah.
Okay.
So pre-COVID, it was much faster.
Pre-COVID, much faster, which means there was less losses to you, right? If you had a last month's rent, maybe you would suffer 1 or 2 months,
Right.
right? Now, it takes just 7 to 8 months to receive a notice of hearing.
Yes.
This is the result of a broken system.
Mm.
This is why so many people feel that the law is for the tenant. So it's not the law that's for the tenant, because the law says, no, you have to pay the rent for whatever reason. Even if you have maintenance issues, you have to pay the rent.
Yeah.
It's a broken system. And unfortunately, a lot of landlords are victims of this broken system because, like you said, they could suffer tens of thousands of dollars in damages. It's no joke.
So the biggest problem is the backlog.
The backlog.
Yeah. But I think it should be solved, this problem, if the board, they speed up the process for the tenants that are not paying rent. Because I feel like from your experience.
Well, there's 80,000 tenants who are not paying rent. How do you speed up that process?
Yeah. I don't know. I mean, like
During COVID,
if you can just let whoever submits the application for not paying rent, I don't know, maybe they hire more staff just for that department. Because I know there are other notices you can submit to the board, if like there's damages or any of that. But I think the biggest problem is for tenant not paying rent, right?
Yeah, one of the biggest problems. Another big problem, in my opinion, is pending sale on a property.
Because the tenant is not moving out.
That's right.
Okay.
So imagine they're not moving out, the property is sold, and they're not paying rent.
Yeah.
Oh, that's
Right,
double.
Yeah.
Well,
That's the
we
worst.
had a case where they
Many.
weren't moving out and then the deal got canceled, terminated, like mutual.
That's
release.
right. Because at least if they were paying rent, sometimes the lawyers push for a close.
Right.
So that buyer will take it over and they'll get paid the rent and they'll continue with the tenancy until they can get to month 7 or 8 to the board. But what if that tenant is not paying rent? Who's going to take over that tenant?
No one.
No one,
Yeah.
right? And that's what results to the buyer backing out.
But let's say they're paying rent, and then the new buyer who wants to buy the house, they want to move in, right? So they have to talk to the board and confirm that they're moving in.
Yes, they have to attend the hearing, right? So the board will hold a
So
hearing.
the sellers and the buyer, they have to attend the hearing.
Correct. They should attend the hearing together. We actually have a hearing coming up first week of November, and we've waited at least, I would say, 8.5 months to get to the board. And I was just informed that the buyer doesn't want to attend the hearing. And they're going to have to, because if they want the board to end the tenancy, they have to say, yes, I am so-and-so as per my declaration.
So who doesn't want to attend?
The buyer doesn't want to attend.
Oh.
See, that's the thing, is you wait so long to get
Yeah.
to this point and then you don't want to attend.
But let's say, okay, they go to the hearing date and then the judge, or like they say, okay, the tenant has to move out. How long do they give the tenant to move out? Is it 2 months?
Sometimes it's 30 days, sometimes it's 60 days, right? But it's not how long they give the tenant, it's when you receive that order. Sometimes you don't receive that order until month number 5, on top of month number 8, right? So the tenant is there over a year and you still don't have that order.
Oh, it depends on when you get the
So
order.
it depends on when you get that order.
Yeah. Oh my God, that can be very messy.
It can. And it often is.
Yeah.
It often is.
Like as realtors, as professional betters of tenants,
Mhm.
like obviously some of the criteria is that your rent shouldn't or housing needs shouldn't be more than 30% of your gross income. Like your credit needs to be a certain amount. But then, obviously there's genuinely good people out there that's gonna pay the rent, but they just can't qualify for it based on what their income is. Like, what about those types of people?
Well, you're going to have to really, really do your research and make sure you're 100% on those type of people, right? Because it's so easy to get them in and it's not so easy to get them out. But I always tell my agents, and I'm going to tell you guys as well, there are 2 websites that you should use as pre-screening tools. Openroom.ca, you got it, and Camly.org.
Yeah.
Okay, because these 2 websites, you can put in the tenants or prospective tenants' names and see if any orders from the board pop up. So if you can see that that tenant owes $20,000 to someone, are you going to bring them into your property?
No.
Probably not.
To expand on Open Room and Canly, these came up because of the whole backlog situation, or was it available before COVID as well?
So Open Room was actually born because 2 very angry landlords came together and said, because there's no bad tenant list because of all the privacy laws, we're going to start a website. So they opened up openroom.ca and they allow landlords throughout the province of Ontario to upload landlord and tenant board orders. So if you go on that site, you can either upload your own order, okay, and make everybody aware of your bad tenant, or you can do a keyword search and see if any prospective tenant comes up. So I often use this tool for to pre-screen tenants, pre-screen prospective tenants. Why not?
I mean, that's the least you can do.
This is,
and it's free, right?
It's free. Yeah. To me, that's kind of like a bad tenant list because it tells you exactly what the tenancy is like, the nature of the tenancy.
So you said you have to have an order from the landlord tenant board?
Yeah. You have to have an order from from the board in order to upload it.
Okay, but it doesn't have to be like finalized the application. Like, do they have to be evicted, the tenants?
No, they don't.
If you just have
as long as you have an order from the board, then you upload it.
But it can't be just where landlords are just disgruntled and they don't like the tenants.
They turn to Facebook for those for those matters.
There's tons of Facebook groups.
Tons. Yeah,
and they're like all the people there, like they're passionate, they keep posting, commenting,
and they have to be careful because usually I call Facebook forums the court of public opinion. Everybody has an opinion, right? But very few have the knowledge or experience on how to deal with these issues. And that's why I say, going back to the agents making mistakes, they genuinely don't know. The public doesn't even genuinely know. So how can some professions know?
It's not necessarily that they have any bad intentions. Obviously, they
want
the best for their clients.
That's right.
They just don't know.
They just don't know.
So now I think the most important question is for landlords. We get asked this: what happens if the tenant stops paying rent? What are their options?
Okay, so for landlords, they always have to serve notice for non-payment of rent. If you're a landlord and your tenant stops paying rent, serve that notice. Don't wait.
Like as soon as the next
day after.
The
day after. If it's a good tenant and they say, I'll pay you next week, then, you're no problem. I still have to serve this notice.
Oh, yeah?
If you pay in full, you void the notice. Right?
Just for the listeners out there, this notice, is it just a regular letter or it has to be
it's an actual, it's the N4 notice for non-payment of rent. We're not giving any legal advice here. I can't give legal advice. Make sure you don't click that.
This is a very casual conversation.
Very casual conversation. If you don't know what that notice entails, contact our firm and one of our paralegals is happy to always assist.
Exactly.
But the notice should always be served in order to save time. Look, we mentioned it takes 7 to 8 months to get to the board, right?
Yeah.
Why wait?
Don't
Right?
delay it.
Don't delay it. If the tenant pays, they pay. They void it, right? They pay to stay. But if they don't pay by the termination date in that notice is then applied to the landlord and tenant board by way of an application. And then the clock starts. Time is of the essence.
Okay.
Right?
So you serve the notice to the tenant.
Serve the notice of the tenant.
Is it by email, mail, or...
Well, the board has their own methods of service. Now you can look up the methods of service on the board website or on our Instagram. We also have a video on the board's methods of service. But email is not an acceptable method of service unless the parties have agreed and there's a signed document. That document is called the consent to service via email form. That basically allows the tenant and landlord to communicate and serve certain notices via email.
So that's separate from the section that says for daily communications on
That's correct.
standard fees.
That's correct. Totally separate. So this consent to service via email form should also be attached to your lease agreement. Have them initial. I know it's so much.
Yeah.
But sometimes you get to the board and you say, well, we agreed in the lease. And then you have a board member that says, okay, well, I'm okay with that. But then sometimes you have a board member that says, well, no, I'm not okay with that. I need the real form. So you don't want to get to the board only to have that board member that's not okay with it to have the matter dismissed, right? You want to make sure that you do your due diligence up front.
So for the notice, once the time period terminates and the tenant still hasn't paid, you submit an application to the board.
You got it.
And you just wait.
Then
Just
it's
wait.
7 to 8 months.
From the date that the application is filed,
Yeah.
it's 7 to 8 months. Not when the notice is served.
Is the
When
application.
it's filed.
And there's, okay, what other options? I think the other option is the cash for keys.
The other option is the cash for keys. Cash for keys, which we talk about a lot, especially in the real estate industry. And the reason why is because of the board delays. Sometimes this is the only option that landlords have. For a cash for keys, I always suggest or recommend a cash for keys be done prior to listing the property. And the reason why is because when you list it and when that property is sold and the tenant is there, they know that you have to pay if you want to leave, right? But if they don't know what your plans are, right, it's better to do a cash for keys to get them out so that you don't have issues with access, taking photos, pictures, video, holding open houses, restricted showing times, and even vacant possession. The tenant is out, the landlord can do whatever they want. They can stage it, they can paint it, they can give it a curb appeal, you can hire a professional videographer or photographer, you can hold open houses, and access to the property won't be an issue. That's why cash for keys should be done prior to the property being listed. But what it is, it's basically an offer made to the tenant in exchange for a termination of tenancy. You're giving them a buyout for them to pretty much leave your property.
Yeah.
But that buyout could be anything. It could be 5,000, 10,000, 20,000, 100,000.
There's no
You
limit.
can buy them a house,
Buy
right?
Yeah.
Buy a piece of land. You can forgive rent arrears, right? We've done cash for keys where the landlord forgives $30,000 in rent arrears if the tenant leaves in 30 days. So there's different strategies to the cash for keys.
What if for the cash of keys you agree with the tenants that you will pay them 10,000, then you pay them the 10,000 and they still don't leave?
So what you're paying for, that's a good question. What you're paying for is you're paying for them to give you a termination of tenancy. So you're paying for them to sign the agreement, to sign the terms of settlement, which are the two documents that are then filed with the board for an eviction order. Once these documents are filed with the board, there is no waiting 7 to 8 months.
Okay.
Because there's a mutual agreement, the parties agreed to end the tenancy, cash was given to the tenant in exchange for a termination of tenancy, and then they changed their mind. The board must terminate tenancy because they don't have jurisdiction to decide on settlements like the cash for keys.
Yeah.
That's generally within like 60 days.
So if the tenant decides to if they change their mind, they would put a hold or a stay on the eviction. The board will then hold a hearing in about 30 to 60 days. These stay hearings are much quicker.
Yeah.
Right? The last one we had, quite rarely happens where the tenant changes their mind. Let's say, for example, in all of 2020, we only had one tenant change their mind, and we did over 1,000 cash for keys transactions in our office. And when we got to the board member said to the tenant, "I can't believe you took money from this poor landlord. I can't believe you're not leaving, and you better leave by the end of the weekend because I'm issuing this order on Monday. So we're not waiting 30 to 60 days to send you the order. You better leave." And that was the best adjudicator I've ever had at the board because he couldn't believe how somebody agreed to leave,
Yeah.
took the money, and didn't leave.
And there's no consequences for the tenants. Like if they start
Wow.
paying all that.
So is there a way to like record, like have that show up on their credit reports maybe?
No. If they don't pay the rent, a landlord can file a claim through the credit agencies and see if that will touch their credit,
Yeah.
but not if they change their mind.
There won't be any like history behind it on
No.
the reports.
You can upload that order to the landlord credit, sorry, the front open room.
Okay.
You say that again?
Open room, right?
Yes.
Okay.
You can upload that to openroom.ca so that other landlords are aware.
So that's basically the only thing that's holding tenants back from being professional tenants
That's right.
at this time.
At this time.
So what's to say like these landlords like we just stop buying properties and we personally just go and be professional tenants?
Well, real estate is still the best investment.
Yes.
I never ever deter anyone from buying real estate. Even those landlords that are frustrated, even the buyers that say, "Why did I buy this property?" Real estate is still the best investment. I'm a landlord myself, right? Sometimes I even get frustrated, right? But never ever let a tenant deter you from building wealth, from owning real estate, right? Just because they're a nuisance, we can always get that person out. Sure, it'll cost you a little bit of money, but the long-term gain in owning real estate is much greater than the short-term gain.
We've been talking a lot from like a landlord's perspective. Maybe we should talk more about like the tenants. What kind of landlords have we seen?
Well, so our firm is a landlord-based firm. So
Okay.
that means we primarily represent landlords, okay?
Right.
But we don't like the shady landlords, the landlords who are slumlords, the landlords who don't want to take care of the property, the absent landlord who doesn't want to have anything to do with the property. Those are not good landlords, and those are not the landlords that we want. But tenants have rights as well. They have the right to peaceful enjoyment. They have the right to quiet property. They have the right not to be harassed or coerced. They have the right to reside in the property without being pushed to leave, right?
Receive proper notices.
And receive proper notices. Landlords must do things in accordance to the law. Okay.
What about like the whole you have to pay the first $500 for repairs on the refrigerator?
Yeah, I see those clauses a lot. You know, even when I was in real estate, I used to put those clauses in.
Yeah.
Only now, I know not now, but
They
when
just don't hold up.
yeah, they don't. So half the lease that we had doesn't bear any weight, right? Even if you have that in your lease, the law says the landlord is responsible. Doesn't matter if it's $1, doesn't matter if it's $50 or $500. The landlord is responsible for maintaining and repairing, and that includes changing light bulbs, changing furnace filters, paying the hot water tank rental fee. This is all maintenance. Cutting the grass, shoveling the snow, salting. It's the maintenance.
I think for the shoveling and snow thing, you have to have a separate agreement.
Yes. So maintenance, exterior maintenance, you can have a separate agreement where you're hiring the tenant. So I'm hiring you to do this service, and I'm paying you X amount. Don't deduct it from the rent. You're paying just like you would pay a contractor to do it. But if that tenant says, "I'm not doing it anymore," then you have to do it. You have to get your son to do it, or you have to hire a contractor to do it.
Just gotta do it.
Just gotta do it. It's a risk involved with owning real estate.
It's true.
What about smoking? What are the rules regarding smoking?
It depends where, because condominiums, they don't allow for smoking, right? So that's why I say make sure you attach the condo rules to the Ontario Standard Lease. Now, oftentimes you have smoking rules in the Ontario Standard Lease for your own property as well. If no rules apply, then no rules apply. But if you don't want them to smoke inside, or if you don't want them to smoke on the property, make sure you are very, very specific in the lease. right? It's highly unlikely that you'll get someone evicted. Just the fact that they know that that's in my lease, I can't do it, is sometimes good enough.
But if they still smoke, and the only thing you can do is just serve the notice, and
Oh, can you evict a tenant just for smoking?
I've never seen anyone evicted for smoking.
it's like,
Personally.
what if I'm renting out my basement and I have allergy, so it's
Now,
harming me?
Yeah, so if you have an actual allergy, if you can provide a medical report, then you can serve notice and then wait to be heard at the landlord tenant
In
board.
8 months.
Yeah.
I think now, like, there's I think a loophole the tenants are using is the marijuana because it's legal. So they
The
say it's for my
medical
mental
purposes.
health or something, right?
Yeah, I mean, they're allowed to have 4 plants. That's the legal limit. Depending on whether or not they have a medical license to smoke it, they have some medical history. I mean, it's also scary because it could be a human rights issue. So if
Yeah.
you're saying, I don't want you to smoke, but the person has some physical issues that need
Yeah.
that marijuana, and you say no, well, you're opening
Yeah.
up yourself to human rights.
But other people, they don't have that problem, but they say, oh, I have it.
That's right. Welcome to Canada.
Yeah.
Clearly, it's a very complicated topic, and we suggest, meeting with a paralegal, right?
It's going to save you tons of, like, sometimes thousands of dollars, right? Just to
Yeah,
talk to an expert.
absolutely. We know so many landlords that make, they fill out the applications, they serve the notices, and then they make a mistake. They make an error. They don't fulfill a condition. They don't fulfill a requirement. And then they go to the board after 8 months or 9 months. The matter gets dismissed, and then they call us and they say, well, we wish we would have called you sooner because we would have at least saved
Yeah.
about a year. Right? And then we have to go and undo what they did.
Yeah.
So if you're experiencing problems with your tenants, definitely reach out to us. This is what we're here for.
Seek independent advice.
Absolutely.
Always speak to an expert, right?
Always. An expert in everything.
Now we're only speaking about long-term tenancy. What about short-term? Because I know they're not covered under the Residential Tenants
So
Act.
let's talk about that.
Yeah.
So landlords can't use the term short term in order to circumvent the act. Okay, so for example, if I own a condominium and I say I'm only renting to you for 6 months, you have to be out of here.
Yeah.
That doesn't mean the rental. That doesn't mean the tenancy is short term. It basically often means that I'm trying to use this short term in order to say that the act doesn't apply and I can kick you out at any time.
Yeah.
No, because there are other factors that will take into consideration at the board as to whether or not that tenancy was short term. Think of an Airbnb. How does that work? There's a sign-in portal, right? You go into the website, you check in, check out. Whatever you're renting comes furnished, right? An Airbnb is often for the traveling, people that are going from one place to another temporarily and then leaving. A short-term rental is if you're staying 6 months, you're bringing your own furniture and you're in charge of your own cleaning, you're in charge of your own toiletry. Well, that's not short-term. That only means that the landlord used that term in order to kick you out and circumvent the act. Right? Just like a hotel. A hotel is for the traveling. And a motel is for the traveling. So there are other things that the board will consider as to whether the tenancy is short-term.
Okay. Is it a gray area or is there?
It's a gray area.
Yeah.
Yeah. I mean, even terms such as landlord and tenant, right? If it's a short term, are you a landlord or a tenant, or are you a guest and a host? When you go to a hotel, what are you? You're a guest.
You're a guest.
When you go to an Airbnb, what are you?
Yeah.
Right? And then all of a sudden we're landlord and tenant in my short term rental.
So what if, like as you said, I have a property, I just want to lease it for 6 months because I have other plans, like I want to sell it or something.
Doesn't work that way.
But what if I make an agreement with the tenant and I tell him, hey, you'll have to rent through Airbnb, and then
Is that person in the unit or out? Is the person in the unit?
No, not yet.
Okay.
Not yet.
So if it's on Airbnb, then the only way that person, the guest, would know about it is from the Airbnb website.
Well, I can tell him I'm going to put it on Airbnb and you will have to rent it through Airbnb. And this way, I think the landlord is protected.
You would also have to find somebody who's willing to do Airbnb for 6 months.
That's right.
Yeah. But the thing is, if it's in Airbnb, then
I'm not saying if it's in your Airbnb you're safe, because if you even Google nightmare Airbnb guests,
No.
guess what? There are guests that don't leave.
So exactly, then what happens, because it's not covered under the Residential Services Act? So can we just call the police and evict them?
You can try. I know that sometimes short-term rental companies don't offer protection. So Airbnb is a very reputable company. Many people rent through Airbnb and they're great success. I've rented through Airbnb, great success, never had an issue. It just takes that one guest to make your entire ownership or experience a nightmare.
Yeah.
But whether it's Airbnb, whether it's short term, whether it's long term, you're dealing with people, right? If you have somebody that says, I'm not leaving, it doesn't matter if it's Airbnb, short term rental, or long term, right? You have to figure out a way to get that person out.
Yeah.
And the police, let's talk about the police. The police have no authority to evict someone. So even if the police arrive at a short term rental of an Airbnb and the guest says, well, I have a tenancy, the police are not going to remove that. The police are going to say, well, you know what? This is out of our jurisdiction.
Go to them.
Talk to the landlord and tenant board.
But what if you tell them, as a landlord, you tell them it's trespassing, or
Yeah.
like, I don't know
Talk
this
to the
person.
board.
But yeah,
Well, how did they get into your house?
yeah, like they were supposed to just stay 2 days, but
That's right.
wow.
So now what happens is the landlord or the property owner would have to apply to the board under an application that the act does not apply.
Okay.
They have to wait 7 to 8 months, sometimes longer, right? Because these applications are not priority.
Yeah.
When they get to the board, you have to prove that tenancy, the act doesn't apply. The board will then send you their order, whether or not the act applies. If the act applies, then you have a tenancy. If the act doesn't apply, then you can evict that tenant. You can hire a bailiff or contact the sheriff to remove that person.
Mm-hmm.
But you need an order. So bailiff is like a sheriff, but in the private sector. So you'll see the bailiff usually evicting commercial tenants who don't pay.
Oh.
The sheriff has a wait time, right? So if you go to the sheriff and enforce an eviction, it takes about 4 to 8 weeks. If you go to a bailiff and you have an order and you have your documents, they'll probably schedule in the next 2 or 3 weeks.
So it's never the police.
Never the police. They won't even touch it. With everybody having a smartphone and a camera, and with the police being in the limelight, they're not going to touch it. It's not worth it.
See, I didn't even know Toronto had a sheriff.
They do. The province of Ontario, I think they have a total of 6 or 8 sheriffs.
Oh, that's it?
That's it.
Oh. So
that's why the delays with the sheriff and the eviction.
Yeah, they're not
too,
even
right?
in every city then.
That's right.
Okay.
So what if this also happens sometimes? If, like, let's say there's roommates. Now it's common, there's roommates. And then one of the roommates, they leave the property. Then is the other roommate still responsible to pay the rent for the other roommate if they're both on the lease?
So it depends on who's on the lease.
Okay.
Okay. If they're tenants on the lease, they're tenants. All tenants are jointly and severally liable for the expenses. But if, let's say, for example, if you moved in there and then you brought in your own roommate, you're responsible if your roommate doesn't pay you or if your roommate leaves because you're on the lease.
So what if the actual person on the lease leaves?
And leaves that roommate
And
behind?
the roommate's supposed to be responsible for the rent, but then doesn't pay. Can a landlord just evict him right away?
Only if there's a tenancy. Roommates and occupants are not recognized in accordance to the act.
Right.
So really, they're unauthorized occupants.
Right.
But if the landlord accepts rent, then they become a tenant. See, things are complicated, right?
Yeah.
So you gotta really be careful which term you use and how you acknowledge the parties.
The rules, they change frequently?
Yes. So not frequently. So every few years, the board makes amendments to the law is amended and changed. And we always provide these changes and updates on our Instagram.
And you guys are always up to date because you're doing
Always.
it day in, day out.
Yeah, constantly solving problems and issues, and
Yeah.
That's what we do.
I don't know if you have any more questions, but if you have any crazy stories or something you want to share.
Lots of crazy stories on our Instagram. Actually, we were telling you guys that we had served notice for non-payment of rent, and the tenant had, I guess, stuck it to the wall with a knife and sent us a photo of it. Actually, not only did they not open the envelope, but they provided us evidence with damaging the landlord's property. So, tenant, thank you for that. And we're going to be using that as evidence. But we get lots of crazy stories, crazy cash for keys stories, crazy unrealistic expectations. Not only from the tenants, there's a lot of landlords who have crazy expectations. I mean, we don't work magic, right? If we don't have a magic wand, we do what we can within the law to get the tenant in.
Awesome. Yeah. So if there's an landlord that they're having issues with the tenant, like, is the best way just to reach out to you guys and ask?
What's your Instagram and contact?
Check us out on Instagram and Facebook, always at Stonegate Legal Services. If they go to our website, stonegatelegalservices.ca, lots of great information there.
Okay.
They can contact us through the website. Our email and office number is there. And they can even book a free discovery call, which is a consult.
Yeah.
So check out our website, stonegatelegalservices.ca.
Really glad
Awesome.
we had you on. I think I learned a couple of new things as well today, and I'm sure anyone who's listening to this learned a lot.
Yeah. This can go on forever. Like
It is. It's a never-ending topic.
It's never-ending.
Never-ending. Thank you for having me on.
Yeah. Thank you so much for coming.
And I'm always happy to help you guys.
Awesome.
Always seek experts.
Yeah.
Yes, in anything.
Yeah.
We'll see you guys in the next one.